hail to thee, Thane of Glamis. All hail Macbeth, hail to thee, Thane of Cawdor. All hail Macbeth, thou shalt be king hereafter.
Stay, you imperfect speakers, tell me more. I know I am Thane of Glamis, but how of Cawdor? The Thane of Cawdor lives, and to be king stands not within the prospect of belief. Say from whence you owe this strange intelligence. Speak, I charge you. As I mentioned in a previous video, huge numbers of technology workers were laid off recently, nearly 100,000 just within the last 2 months. The tech workers felt that they were victimized, betrayed, misled, etc. And maybe they were, but they're finding jobs now, so they're not in any kind of real financial difficulty. If they were, and if they're non-citizens, potentially they could be inadmissible to the U.S. or deportable from the U.S. for that reason alone, financial difficulty. And that's what this video is about. I'm Catherine Park, an immigration attorney in the United States. The public charge rule went into effect largely in its current form in 1999 and deems to be a public charge any non-citizen who receives certain payments from the government for their main source of income or who's been hospitalized long-term at the government's expense. A couple of years ago, during the Trump administration, the public charge rule was revised to become rather draconian, with all kinds of new factors added to the calculation of who was likely to become a public charge. Then the Biden administration changed the rule back to what it was. But because it's happened before, the current public charge rule could be changed back yet again, or it could take a different form altogether. With that being said, let's discuss technology workers who may be here on an H-1B visa. An H-1B non-citizen would only be deemed to be a public charge in very unusual circumstances. First of all, if you're an H-1B, you have to have a job that requires a bachelor's degree at a minimum. If you're laid off, you have 60 days to find a new H-1B employer. And that's if you have 60 days remaining on your visa. And DHS has discretion to eliminate or shorten the 60-day grace period. If we should fail.
We fail.
Is this a dagger which I see before me? I go, and it is done. The bell invites me. Hear it not, Duncan, for it is a knell, which summons thee to heaven or to hell. To be deportable as a public charge, the non-citizen has to become a public charge within 5 years of entry into the U.S., and the reason why the person became a public charge must be found to have arisen before their entry into the U.S. So would a laid-off technology worker in H-1B who doesn't find a new job be deemed to be a public charge? Well, the H-1B visa holder would be deportable for violating the terms of the visa since the person doesn't have a job anymore, and DHS could place him or her in removal proceedings for the overstay, but probably wouldn't do so for being a public charge. Now, both grounds of deportability have to be proven by clear and convincing evidence, and the burden of proof is on DHS. But being deportable as a public charge requires a couple of things to happen. 3 very specific things. 1. Within 5 years of entry into the U.S., the non-citizen received from the government, federal or state government, certain services that require payment of a fee, and the individual didn't pay. 2. The government demanded payment for the services rendered. 3. The individual didn't pay. Thou canst not say, I did it. Never shake thy gory locks at me. Do not muse at me, my most worthy friends. I have a strange infirmity, which is nothing to those that know me. So let's try to think of a complicated medical scenario that might happen to you as an H-1B visa holder. Let's say you were laid off, and within 5 years of your entry into the U.S., you were placed in long-term care because the doctor believes you won't ever recover and you have no one to look after you in the United States. Would you be deportable as a public charge? Maybe. Although Medicaid doesn't have to be repaid, if it's used for long-term institutionalization, it is included in the public charge analysis. But the reason for the non-citizens being institutionalized has to have arisen before entry into the U.S. for the person to be deportable as a public charge. However, they could change the law on that. The government is in charge and the laws do change. Let's discuss the factors that lead to a finding of inadmissibility as a public charge. Age, health, family status, assets, resources and financial status, education and skills. The consular officer, if you interview at the consulate or embassy, will assess whether the totality of the circumstances trends in your favor. You could also submit an affidavit of support. That's Form I-864. And for some types of immigrant visa applications, the affidavit of support is required. Most family-based immigration and some employment-based immigration applications require it. Your sponsor has to meet certain income requirements, and they need to guarantee your obligations to the government if you receive means-tested benefits that have to be repaid. Means-tested refers to low-income benefits such as SSI, but not SSDI, which is Social Security Disability Insurance, which is based on disability and work credits that you've earned. Now, many types of benefits don't count against you for public charge purposes. Non-cash benefits such as SNAP benefits or other nutrition assistance programs, Children's Health Insurance Program, Medicaid, housing benefits, immunization benefits, disease testing benefits, other supplemental or special purpose benefits. Also excluded are payments for childcare, energy assistance, disaster relief, and pandemic assistance. And some non-citizens are not subject to the public charge rule. Asylees and refugees, victims of human trafficking, victims of certain types of crimes, self-petitioners under the Violence Against Women Act, special immigrant juveniles, beneficiaries of more than 24 country-specific programs. Generally, the humanitarian admission categories are not subject. I will not yield to kiss the ground before young Malcolm's feet, and to be baited with the rabble's curse. Though Burnham would be come to Dunsinane, and thou opposed being of no woman born, yet I will try the last. Leon Macduff. And damned be him that first cries, hold, enough!